Good morning, everybody, and thank you for joining us. So today's webinar is about data protection, and it's an opportunity to catch up with the changes that have been afoot and those that may be coming up. I will be speaking with my colleague Kitty Rosser today. So we are both based at Burkitt's. Kitty is the legal director in our corporate team and heads up the data protection team. I'm a partner in the commercial litigation team, and I'm largely exposed to the claims that our clients experience in relation to data breaches brought by the individuals. Our agenda for today is a regulatory roundup, followed by a brief case law review from my perspective, and then international data transfers. It's a very apt moment or time to be going through these because Kitty reminded me this morning that next week is the 4th anniversary of GDPR. I'm sure it feels like a lot longer than 4 years for those of you dealing with this on a day-to-day basis, but I can assure you it is only 4 years. Once Kitty has finished with the international data transfer update, then we'll have an opportunity to have a question and answer session. I'll now hand over to you, Kitty.
Thank you very much, Maria. And I am going to start my roundup this morning with a welcome to our new Information Commissioner, John Edwards, who took office on the 4th of January this year. John will serve a 5-year term as our Information Commissioner. And as we saw with Elizabeth Denham, who joined us after a period as the data regulator for Canada. We also have an international flavour with John Edwards, who joins us hot off a 8-year stint spent as New Zealand's Privacy Commissioner. And John has begun his term by undertaking a 3-month listening tour, where he's been out and about talking to people and trying to have a bit of an ear to the ground and take the temperature as to what issues are actively concerning people around data. And I've put up on the screen an extract from an article that John put out, which I think shows that he's read the temperature in the UK pretty well so far. So he comments there on the fact that we spent 2017 and 2018 frantically preparing for the arrival of GDPR, and then 2019 adapting to the new law and practice before going straight into 2 years being dominated by a global pandemic. And just as it seems as though we may almost be coming out the other side of that and facing a slightly easier year in terms of data, we're instead faced with government proposals for reform of data protection law and the introduction of a new Information Commissioner. Now, reassuringly, I think John has said that his focus is very much on ensuring that the ICO will make the transition, as we maybe change our laws slightly, as seamless and painless as possible. So far, so good, and hopefully good things to come down the line from Mr. Edwards. The next thing that we're going to touch on our roundup is an enforcement summary. So we're going to look back for about 12 months, so back between the 1st of May 2021 and the 1st of May 2022, to see what's been happening in terms of ICO enforcement. And we're going to start with the numbers. So you can see on screen that in the 12-month period just gone, we have seen 40 monetary penalty notices issued by the ICO, together with 25 enforcement notices. And 19 organisations actually received both a monetary penalty notice and an enforcement notice in respect of their activities. And sticking with the numbers, we can see that 36 of those monetary penalty notices related to PECA breaches. So that's breaches under the Privacy and Electronic Communications regulations, and those all related to breach of the marketing rules, specifically the requirements around collecting marketing consent and screening against opt-outs and telephone preference service registrants, etc. only 4 of the fines were actually brought under the Data Protection Act itself, relating to more general data protection breaches. And in terms of value of the fines, the smallest fine that we've seen during that period was a very small £2,000. And then at the other end of the scale, we had 2 fines coming in at £500,000. And taken across the 40 different fines, we're coming out with an average of just under £160,000 for each fine that was imposed. And so from that, I think there are a couple of messages we can take. Firstly, clearly marketing compliance statistically remains your highest risk area in terms of seeing enforcement action being taken against you. And the second thing, on a slightly more positive note, I hope, is that we haven't in the last 12 months seen any more of these mega fines, the kind of tens of millions pounds value fines that we saw issued against BA and the Marriott Hotel Group. And I know there was a lot of concern when those fines came in that they were going to be the start of a new level of fines that we're going to be seeing routinely. So hopefully it'll be quite reassuring to a lot of you to see that actually in the 12 months that have passed since, we haven't seen any evidence of the ICO looking to impose fines at that level in cases generally. It's very much still governed by the severity and the culpability for breach and the impact of it. In terms of sectors then, we can see that the finance, insurance and credit sector has led the way in terms of enforcement actions, followed quite closely by the marketing sector, unsurprising. And further sectors that have attracted multiple cases of enforcement are retail and manufacture, charitable and voluntary sector, land and property services and general business. And then you can see on the screen a list of the other sectors which have just experienced a single enforcement action. So the next thing I'm going to talk about is some new codes that were introduced by the ICO in the last 12-month period. Now, in terms of the status of codes, it's worth mentioning that the Information Commissioner has a statutory obligation under the Data Protection Act to introduce codes around certain specific areas. But the codes themselves don't actually have direct statutory effect. So you cannot be sued or face enforcement action for failure to breach the code in and of itself. However, where they come into play is if you do have a breach and it concerns subject matter covered under a code, the regulator or the courts, depending on which arena you are in, will look quite carefully at the code and whether you have adhered to the code in determining whether you may have breached your obligations or duties under the primary legislation, so UK GDPR, Data Protection Act 2018. So not with direct statutory effect, but nevertheless still very important to be aware of them and to adhere to them. So the first code that we're going to mention is the Age Appropriate Design Code, better known as the Children's Code. That took effect in September 2020, but we've put it into this 12-month roundup because there was a 12-month transitional period attached to it. So the date that most people have been aiming at in terms of compliance with that code is actually September 2021. And that code applies to the provision of information society services that are likely to be accessed by children. So a couple of points to pick up on here. Firstly, what is an information society service? Well, it basically means a for-profit online service. So it would include things like apps, websites, social media platforms, streaming services, marketplaces, or connected devices such as connected toys. And in terms of the likely to be accessed by children, be aware here that you don't need to have set out to have created an online service for children or aimed specifically at children to be caught by this. What you need to think about is it likely that children are going to be accessing my service? Even if it is targeted at an older demographic, but children are still likely to access it, then you need to have regard to this code and make sure that you are complying with it. And a point of clarity here, when we talk about children, for the purpose of this code, we are talking about under 18s. And I know that this has caused a little bit of confusion because under GDPR, we have those specific provisions around consent, the age at which a child can give consent for their data to be collected in an online context, and that for the UK is specified at 13. But do be aware that for the purposes of the Children's Code, you've got that additional sector of 13s to 18-year-olds, which are caught here as well. And in terms of what the code does, it sets out 15 standards that you need to ensure you are meeting in relation to your information society service. And those standards are looking at really pulling out some of the issues relevant to protection of children that you need to think about when you are complying with the data protection requirements. So they're not setting out additional requirements as such, they're really just aimed at focusing you in on specific issues that you need to think about to make sure that you're complying with those general obligations that you have under the existing legislation. And the good news is that the ICO has created a really helpful Children's Code hub, which is on its website, and there are a number of different tools and resources on that hub, as well as the text for the full code and a useful summary or short form of the code, which will help you make sure that you can work your way through it and that you understand what you need to do to comply. The next code to mention is the data sharing code, and this came into force in October of last year, and it covers all routine or ad hoc sharing or pooling of data between data controllers. So note that this code isn't intended to cover sharing of data between controllers and processors, it's just sharing between different controllers. And again, the code is very practical, so it sets out a series of steps or issues that you need to consider to make sure that when you are sharing data, you are doing so in a way which will protect privacy and comply with the regime set out in the legislation. And again, ICO has really helpfully created a data sharing information hub with lots of tools and resources and access to the full text of that code. So aside from bringing in formal codes, the ICO has also been pretty busy over the last 12 to 24 months in various consultations. Now, most of these consultations have now closed, but we haven't actually seen any particular material output from them as yet. So we've really flagged these as areas to watch. These are the things that we think we're going to see some updated guidance or codes or tools coming into effect in the relatively short future. So areas to think about: anonymisation, pseudonymisation, and privacy enhancing technologies. Use of data for employment purposes. This is something that's probably going to be relevant to everybody. We already have an employment practices code from the ICO, but it hasn't been updated post GDPR, and it's really becoming quite outdated now. So an update to that has been quite long awaited now, so it will be really good to see an updated employment practices code coming into effect. There's also been a focus on use of data for research purposes and understanding exactly how those research provisions under UK GDPR might be applied in practice. The ICO has also been looking at its own activity, and it's been consulting on its regulatory action policy. Now, in terms of risk, this is a really interesting one because the regulatory action policy sets out when the ICO will take different types of enforcement action, and also how it determines the amount of a fine or monetary penalty notice that it will impose. We've also seen some focus on use of data for journalistic purposes, and also use of data in the context of AI. And we've recently seen launched a new AI and data protection risk toolkit following consultation around a beta version that's been floating around for the last few months. There is also some attention given to reporting and making data on security incident trends more readily available to us. And of course, direct marketing, as ever, remains under the spotlight. A new draft direct marketing code was prepared kind of several years ago almost now, and was out for consultation. Work on that was paused during the pandemic. It has now been resumed, and so we're hoping that we are going to see a new formal code come into effect on that quite soon. And the last really substantive thing that I want to cover today, which we really couldn't provide a regulatory update without, is a reference to the new data reform bill. No doubt lots of you will have been following the Department for Culture, Media and Sports consultation on data and new direction. Now, that actually closed on the 19th of November last year, but it attracted over 3,000 responses. And we heard in the Queen's speech last week that we are going to see some follow-up from that consultation in the form of a data reform bill, which we are expecting to come out during the course of this summer. And we don't, of course, know exactly what that bill is going to contain yet, but we can start to think about areas of focus that might be in it based on the issues that were covered under the DCMS white paper. So issues that we are expecting to be addressed: potential easing of some of the accountability measures that were seen more as tick box issues rather than actually achieving any meaningful limitation of data risk. So a suggestion that we might see the end of the requirement to document legitimate interest assessments or to maintain really detailed records of processing activity. Even a suggestion that the statutory requirement for certain types of organisation to appoint a DPO may go. We're also seeing a potential for limitation for access to data subject rights, with a suggestion that we may see a reintroduction of the small fee that we previously had under the Data Protection Act 1998. New lighter touch cookies rules are on the horizon, and I think would probably be welcomed by everybody. So potentially doing away with that requirement to obtain active tick box GDPR standard consent before any non-necessary cookies are placed. And of course, a facilitation of international data transfers, and that's something that we're going to look at in a bit more detail later on. And finally, potential reform of the ICO itself. So the overall aim that the DCMS has expressed is to create a pro-growth, outcomes-focused and trusted data protection framework that will be overseen by a more modern ICO, with the intention of reducing the compliance burdens on businesses and supporting and encouraging innovation. Now, initial feedback to that, of course, has been lots and lots of discussion about how might reforms of UK law sit alongside our EU adequacy decision that we are dependent on for the free flow of data between the UK and the EU. Now, one of the stated aims of the consultation has been to ensure that we see a renewal of that adequacy decision, but quite how the details of that will play out, we don't yet know. So my final word for this section is to leave you with a top tip, and that's really just a reminder that the ICO website is a really, really valuable resource for everyone. There are an increasing number of excellent resources on the website. There are templates, toolkits, interactive self-assessment questionnaires, checklists, activity trackers, all sorts of things to help your practical day-to-day compliance. So do take the time to familiarise yourself with the resources that are there and free for everyone to use. And of course, also worth checking in occasionally to keep up to date with the latest news from the ICO and to keep a bit of a track on what enforcement action it's taking. Right, so I'm going to pass back over to Maria now, who's going to deliver the case law review for us.
Thank you very much, Kitty. So I just want to spend a few minutes setting the scene and reviewing what the claims for data breaches landscape looked like prior to around about mid-2021. And I'm going to focus on three areas which were really prevalent. One is the ambulance chasing approach to data protection breach claims. And then two, the cookie policy claims and the serial cookie monsters. And then Lloyd v. Google LLC, but as per the Court of Appeal at that stage. So the ambulance chasing approach to data protection breach claims is exactly what it sounds like. So companies were set up whose business model was to sign up as many victims, as they would term them, of data breaches as possible. They had large-scale advertising. They would post updates about known wide-scale data breaches or cyber attacks, and then they would get as many people as they could signed up on CFAs and then send out letters before claim. They were often of a nuisance factor level, the claims we're looking at. They were perhaps not very valuable at all, but the letters all had the same format, so they would be very long, possibly 9 to 12 pages. They featured not only data regulation breach aspects of claim, but also misuse of private information, breach of confidence, negligence. They threatened high court action rather than keeping it at county court level, and sought recovery of after the event insurance premiums. They basically loaded these letters to look as cumbersome, difficult, and hard to handle as possible, with a raft of various bases for claims beyond just a data regulation breach. As I said, they were often in relation to trivial or minor breaches and of low value. So from an organisation point of view, they were often settled at a very early stage, because although practitioners may have felt that the claims the party was making may not have had substantive merit, the amount that was being sought couldn't justify the management and legal costs that would be involved in defending them, but also because there was this risk that they would issue, and they did issue, so it wasn't just an empty threat, they did actually take claims to the High Court rather than keeping them at the county court level, where they would have been allocated to the small claims track, and therefore cost protection would have been afforded. We then had the rise of the cookie monster. And these were people who were simply trawling websites to find those websites whose cookie policies were not compliant. And then they would take screenshots to show how non-necessary cookies had been applied on their devices without the requisite permissions, and they'd send letters before action, usually alongside a without prejudice letter, which asked for something like £750 to make them go away. Again, a nuisance factor, low level value, but incredibly frustrating. There was one particular lady who gained some notoriety up and down the country, as I understand it from speaking with colleagues in other practices, up and down the country. There was pretty much no region left untouched by her letters, and no legal practitioner working in data protection who had not experienced clients receiving letters from her. She targeted business-to-business websites, which she had absolutely no reason to be on, though she wasn't seeking their services or their goods. They weren't consumer-facing websites. But she sent out, well, I would imagine thousands of letters from what people have said, demanding compensation from them. And there was, as I say, there was no regions she didn't touch. But by mid-2021, she wasn't the only person adopting what was turning into quite the cottage industry. And we understand that there were forums available where these individuals were uploading information about websites that people could go to, which wouldn't be compliant, and on the back of which they could send these letters. Lastly, we had the Court of Appeal's decision in Google, which found that it was not necessary to show that there was distress caused in order to be able to make a claim for damages for a breach of the data regulations. So this was seized on by both ambulance chasers and the cookie monsters as part of their forum, and it was very difficult to argue against when you had a Court of Appeal decision, even though we were all aware that there was a Supreme Court, it had been appealed to the Supreme Court and we were still awaiting their decision. The culmination of all of this was that businesses were receiving regular onslaughts of frankly spurious claims with relatively limited merits, if any, in some circumstances. And even though arguments were being put forward by those representing the data controllers, the reality was we had no meat to add to the bones of our arguments. There was nothing coming through from the courts to support the arguments that were being put forward. And there was a lack, understandably, of willingness for people to take those matters to court and expose themselves to the legal expense and risk associated with any litigation. And that was inevitable when you're looking at relatively new regulation coming through in a relatively new area of law. However, in 2021, just like waiting for the number 11 bus, 3 cases came at once. They were actually spread out through the year, but within the same year. And what was even more helpful is they proved useful in being able to attack what were the spurious and unmeritorious claims. So we had Mr. Warren and DSG Retail. DSG Retail had suffered a complex cyber attack in which the attackers had infiltrated the computer systems, had installed malware and accessed customers' personal data, accepted there was a breach. Mr. Warren claimed that his personal information or data had been compromised and that he had suffered distress as a result. But he also claimed, and that's the crucial part for this particular case, that in allowing the third party unauthorized access to personal data, in relation to which he had a reasonable expectation of privacy, this was an unjustifiable infringement and a misuse of his private information, which the defendant had failed to take adequate steps to protect. So in essence, what he's saying is, you had a duty to keep my information private and confidential, and you failed in that duty because you were breached and the information was taken. Well, the High Court decision said, no, that's not the case. It may amount to a failure, but it's not positive conduct, and breach of confidence and misuse of private information require positive action on the part of the person holding the information, i.e., they would have had to, DSG in this case, would have had to physically or electronically hand over the information, take a positive step to provide that information. That's not what happened, obviously, because they were the victim of a cyber attack. The court also clarified, not that it necessarily needed clarifying, but they did, that neither breach of confidence nor misuse of private information imposes a data security duty on holders of information. Other regulations do, accepted, but the claims should be based on that, not on the misuse of private information or breach of confidence. The court also touched on their view that there would be issues with the recovery of after the event insurance premiums by the claimants, and this was bringing in these cases into line with the consistent position in most other areas, which is now that you cannot recover those after the event insurance premiums from the defending party. So that was very helpful, because what it did was strip away these extra elements that were going into these 9 to 12 page letters, and which actually, if you're looking at arguing them, were relatively complex elements of claims and costly to deal with. We then had Rolf and others, Veal Wansborough Vizards. This one will resonate with so many people, I think, because the first 2 claimants owed a sum of school fees. The school instructed the defendant to write to them demanding payment. The defendant sent the demand, but due to a one-letter difference, it went to the wrong email address. Somebody entirely unconnected immediately picked up on the fact that it wasn't for them, notified Veal Wandsborough Vizards, who said, could you please delete? Confirmation was received very promptly that the email had been deleted. Now, the reality is that is the type of breach that happens frequently in any organisations, in any sectors, because it's down to human input and small mistakes, such as one letter making the difference on an email address. I have used this quote extensively, and it's possibly one of the most useful quotes to come out of some High Court decisions in recent years. And I don't know if the judge had had a bad day, or if he felt that the claim before him was, as probably Veal Wandsborough Vizards did, completely without merit. He also may have had an idea of what was coming through the pipeline in terms of claims of this nature being run by these businesses set up in the ambulance chasing model, and saw an opportunity to be able to draw a line under this kind of activity. And I've extensively quoted some of my favourite parts of his judgment, but the points that he made very saliently was that the idea that in the 21st century, a single breach which was quickly remedied resulted in the kind of distress and even making somebody feel ill was simply not acceptable. And also that there was no credible case that distress or damage over a de minimis threshold would be proved. And then he went on to say, in the modern world, it is not appropriate for a party to claim, especially in the High Court, for breaches of this sort, which are frankly trivial. I think he had a fair point. They were, and they were because the claim was insisted on being brought in the High Court. They're wasting court resources and time, but also money, because High Court litigation is always more expensive than county court litigation. And then lastly, we had Lloyd v Google, but the Supreme Court. And the Supreme Court overturned the Court of Appeal decision. So Mr. Lloyd had claimed, amongst lots of other things, because it was a multi-party action type of claim, but that an individual was entitled to compensation without proof of material damage or distress whenever a data controller failed to comply with any of the requirements of the Act. The Supreme Court held that that was not correct. There still had to be a link between damage and distress and the breach in question, and that there needed to be proof of material damage or distress, not just a breach has taken place. So how does that help us, and what does the landscape look like now? Well, sunnier, I think, from our perspective in defending breach claims. The cases are all high level, which is at High Court and obviously the Supreme Court. That's important because it means it can be cited, it can be relied upon. It's not a low court which may be overturned or appealed by the High Court. The High Court has had the ability or the opportunity to give its view. And so we are now, and the Supreme Court has as well, and we are now clear that any distress must be properly shown to be linked to a breach, and distress must have taken place. Claims for misuse of private information and breach of confidence and negligence fall away where you've got cyber attacks because of the lack of positive use of that information by the data controller. And there is no right to bring claims with a de minimis value, which was where arguably so many of the claims that were being brought would actually sit. So these cases provide armour in the arsenal of dealing with the spurious claims which still find their way to businesses. But they're more than just that. In reality, what we have seen is that there has been a marked downturn. The cookie monsters, I won't say are eliminated because I suspect that's not the case, but they have certainly quietened down from what we're seeing in practice. The business models for the ambulance chasing approach is questionable as to whether it's going to continue. And there has been, again, it's seen in our practice, a marked drop in the number of claims coming through of that nature, and of the claims that were afoot when those cases have come through, a lot of them have died a death and gone quiet without any further action. So all in all, I would say that the cases have had a sensible impact. They've brought clarity to the claims arising from data breaches, and they have given reassurance as to exposure in an area where even cybersecurity experts say it is always a case of not if, but when a breach is, as an attack is likely to happen. I think it's also given a healthy dose of common sense, which was needed in the face of these rising spurious claims. I'm now going to hand back to Kitty, who will take you through international data transfers.
Thank you very much, Maria. I think it's fair to say that international data transfers have given us one of the biggest headaches that we've seen in terms of practical compliance with data protection law over the last kind of 12 to 18 months or so. And we've really had a kind of a double whammy here. First of all, we had the Schrems 2 case, which introduced the requirement for us to undertake transfer risk assessments. And secondly, this is one of the first areas in which we are really seeing a material divergence between what we need to do to comply with UK data protection laws versus what we need to do to comply with EU data protection laws. So even though there has been no technical separation in terms of the actual requirements set out in the legislation, the way in which this is being implemented, the resources, the tools that we are being required to use to meet those requirements are now different between the UK and the EU. And I'm slightly conscious of time here. So there is some detail in the slides which I am not going to talk through, but which I hope will be useful to you, because we're going to send you the slides out after the session, so you can go back to them then and see the additional detail. But what I really want to focus on in the short time I have to talk about this is firstly deciding the basis or mechanism that you are going to use to actually make a transfer of data outside of the UK or the EU, and understanding why knowing whether you're operating under UK or EU GDPR is really important in that respect. And then we're going to talk a little bit as well about the actual transfer risk assessment. So there is this general prohibition under GDPR which says that we cannot transfer people's personal data outside of the UK or the EU unless we have fallen under certain mechanisms or bases. And when we talk about transferring, this could be a proactive thing. It could be us deliberately sending a package of data to a recipient in another country, or it could be something that happens quite kind of in a behind the scenes way almost. It could be that we're using a software as a service platform, and actually that's being provided by a US provider, and all of the data in the cloud is ultimately being stored on servers in the US. So it could be something that we're very aware that we're doing, or it could be something that we're doing almost without really thinking about it. So in order to overcome that general prohibition, there are three options that we can consider. The first option, and the one we always go for where we can, quite simply because it's the easiest, is to look at whether there is an adequacy arrangement in place which recognises that the data protection laws and protections in the data importer's country and the recipient's country are broadly equivalent to the ones that we have in the UK and the EU, which means that we can simply go ahead and make the transfer without needing to take any further measures. If there is no such adequacy arrangement in place, then we move on to considering whether any of these safeguards, which are listed under Article 46 of the EU and UK GDPR, might apply. Now, these require more proactive action from us, and generally they require us to enter into a particular form of agreement or to document the arrangement in some way. In cases where there is no adequacy finding, there's no safeguard that we can reasonably apply, the third option is to rely on one of these specific exceptions, which are set out in Article 49 of the UK and EU GDPR. But the commentary on this makes it clear that these should really be seen as an option of last resort. So in order of preference, we firstly look for adequacy, we then consider safeguards, and failing both of those, we can then look at whether one of the exceptions applies. And turning now to why it's important to understand which law applies here, I said in this box at the beginning that the first thing to be considered is whether you are processing the transferred data subject to the UK GDPR or to the EU GDPR, or even subject to both of them. So if we look at adequacy, post-Brexit, the UK adopted all of the adequacy decisions that had been made by the EU Commission, but that only impacted adequacy decisions that were in place at the point of separation. So what we now have is a situation where the EU has actually issued its first new adequacy decision since that time, which was the finding in respect to South Korea made in December of last year, but the UK has not yet made an equivalent adequacy regulation in respect to South Korea. So if you are transferring data subject to EU GDPR to South Korea, if you're doing that, you can send it under the EU GDPR, relying on that EU Commission adequacy decision. But if you're sending data from the UK under the UK GDPR to South Korea, there is no equivalent adequacy regulation for us. So for the UK position, you would need to then look at the safeguards and implementing one of those safeguards or relying on an exception. So when I talk about there being now a material difference between the UK and the EU position, this is the kind of thing that I mean. Moving on then to the safeguards, we also have a separation between the UK and the EU position in terms of what you need in terms of documentation. Now, those of you who are familiar with Article 46 will know that it actually lists out quite a range of different potential safeguards that you can use. Things like binding corporate rules for intergroup transfers, specific legal instruments that are applicable just to transfers between public authorities or public bodies. There's also been a lot of chatter about the potential to rely on approved certification schemes or codes of conduct as an alternative basis in the future, but we don't actually have any such approved schemes in place yet. For most organisations, for most transfers that they make, the safeguards that they're going to be concerned with are the standard contractual clauses and the the new UK equivalent of those. So to look into now the different mechanisms that you can use, you can see from the diagram on screen that in the UK there are currently 3 options that you can consider. You can still rely on the old EU standard contractual clauses, or you can consider using the new UK documents which take the form of the International Data Transfer Agreement, or IDTA, or the addendum. for the EU, sorry, your options are a little more limited. So there is now only one mechanism to consider, and that is the new EU standard contractual clauses. So in terms of when you might use different of these mechanisms, use of the old EU standard contractual clauses for transfers made under the UK GDPR can still go ahead until September of this year. And we have a slightly ironic situation here where we can still use the old EU clauses for transfers under UK GDPR, but they have actually now been discontinued for transfers under the EU GDPR. So we have a strange situation where use of an EU document is permitted in the UK, but not the EU. The key thing to note around the old EU SCCs is that there is a long stop date which applies to these. So whether you have historically entered into EU SCCs or you're looking at entering into a new arrangement using them between now and September of this year, you will need to have migrated those arrangements or repapered your legal documents to move across to the newer documents by 21st of March 2024. And you do need to complete a transfer risk assessment when you're using old EU SCCs. So that would mean if you're entering into new ones, you need to complete the risk assessment before you start the transfer. And our advice is that if you are relying on a historical arrangement using old EU SCCs, we've interpreted the guidance and the rules to mean that actually you should be revisiting that and carrying out a transfer risk assessment at this stage as well. So in terms of suggested use cases for these documents, we would suggest that you continue to rely on old SCCs that you already have in place on a kind of holding basis until you've repapered within that long stop period. And you may also want to consider using this if it's what you're familiar with, if it's what you've used before, and you're entering into a new short-term transfer arrangement that you're going to be putting in place before September of this year, and which you anticipate will have concluded, or the transfer will have stopped by March 2024. So if you are entering into a longer term arrangement for transfers from the UK, or if you are entering into a new arrangement after September of this year, then your primary option for the UK will be to use the new International Data Transfer Agreement, which came into effect in March of this year. Now, this is still relatively new to us, and we don't even have the ICO accompanying guidance yet. We have been in really regular contact with the ICO to try and keep up to date with when we are expecting to see that, and they won't be drawn beyond, we hope to have it released before the summer. So we're keeping an eye on it, but we don't yet have a concrete framework for that. So what we would suggest is, if you are going to be entering into new transfers subject to UK GDPR, which you expect are going to continue beyond March 24, or which you don't think are going to be in place until after September of this year, then you look to the new International Data Transfer Agreement. Now we also have a new addendum document for the UK. Again, that also came into force in March of this year, and again we're still waiting for the ICO guidance. Now this document is intended to be used alongside EU SCCs, but it's really important to note that it can only be used with the new EU SCCs. So you cannot simply add this to an arrangement where you've entered into old SCCs. And in terms of practical use of this, the value of this is it is a much shorter and easier document to complete. So if you have a transfer situation where you are subject to both UK and EU GDPR, then you can use the new EU SCCs to tick your compliance box for the transfer under the EU GDPR. And rather than entering into the whole full form IDTA to tick your UK compliance box, you can instead use this addendum, which is in practical terms an addendum to the EU SCCs to ensure that you've ticked the UK compliance box as well. So this is going to be particularly valuable for multinationals and potentially also anyone who is proactively selling goods and services both to a UK market and into the EU market as well. So in terms of the transfers under EU GDPR, as things stand, your only option currently is to use the new SCCs. If you still have historical arrangements in place for EU transfers using the old SCCs, then you have until December of this year to repaper those arrangements and put the new SCCs in place instead. So I'm going to just move on now to transfer risk assessments. So the point of this was that it was recognised that when we are transferring personal data to overseas territories, we might be putting in place these agreements, these standard contractual clauses, but actually they may not be giving the protection that we expect them to be giving to individuals. And that's because the recipient of the data in that overseas territory is going to be subject to local law and practice. And in particular, they are going to be vulnerable to requests from local law enforcement bodies or security bodies to access or even intercept data that is being sent to them. And when that happens, it is going to fundamentally undermine the protections that are set out in those standard contractual clauses or transfer mechanisms that are being implemented. So it will mean that despite having put these measures in place, we're not actually achieving the objective of ensuring that an individual's data is protected to the same degree as it would be if we'd kept it in the UK or in Europe. So in the case of Schrems 2, the European court said, actually the way that we need to deal with this is when you're using these mechanisms, you also need to undertake a transfer risk assessment where you look in some detail at the law and practice in the territory that you're sending the data to in order to identify whether your data could be accessed or intercepted, and also how people might enforce the rights under these mechanisms in those overseas territories. And if there are issues, then you need to think about what additional practical security measures could be put into place to minimise or mitigate against those risks. So in practice, you are going to require input from local lawyers to undertake these assessments. And a few bits of advice based on our practical experience to date. Finding local lawyers who are willing and able to complete these assessments can be quite challenging. You may need to approach several different firms in order to find one. And you may find that the costs and the timetables to complete the assessments vary quite widely. So our key tip, allow plenty of time, both to find a lawyer and to then potentially sit in a queue waiting for that lawyer to be able to pick up your particular assessment. The other point that we would say is make sure that you provide really clear instructions to the local lawyers about what you want. Do you just want them to complete the risk assessment for you? Or do you want them to give you some additional advice around what practical security measures or additional measures you might need to take to respond to any risks that they've identified? And do you even need them to help you put together some drafting or wording that you can put into your transfer agreements to document the fact that you've done this assessment, what you've looked at and what measures you've agreed on? And I've added to the bottom of the slide there some suggestions as to some resources that you might find useful in approaching this. Now, final word on this issue relates to a question that we get a lot. And you've probably all seen in recent weeks there has been talk about a potential new privacy shield arrangement for transfers to the US. And we've had a lot of people saying, well, can't we just wait until they get the new privacy shield up and running? Short answer, no. And there are a number of reasons for that. Firstly, if and when we have a new privacy shield, it will only apply to transfers to the US, not to other territories. Secondly, the negotiations are between the EU and the US, so it's not going to be effective for transfers from the UK in any event. And even when it comes in, we have already had quite a lot of commentary from the likes of Max Schrems and his privacy activist counterparts, indicating that they will be seeking to challenge it in fairly short order. So it will have to be stress tested before we know whether it will provide a longer term option. So as I said, there is more detail in the slide. It's a really big topic, so there's only so much I can say within the time we have today. I'm aware that we are running very close to time, but I am going to bring Maria back in now. And for those of you that are able to stay around for a few minutes, we will pick up on any questions that you might have.
Thank you very much, Kitty, and thank you all for listening. We do have a couple of questions that have come through. So perhaps, Kitty, I've seen a couple I can direct to you. So could you please tell us in very short terms what is happening with PECA and when it will be replaced, to the extent that you haven't covered that already?
Okay, so PECA, the Privacy and Electronic Communications Regulation, this is going back some years now, and some of you may recall that when we first had the introduction of GDPR nearly 4 years ago now, it was intended that we would also have a new e-privacy regulation come into effect at the same time that would govern our use of cookies and set out the more detailed marketing regulations, details of when consent was or was not needed, that would apply on top of GDPR. And in the event it hadn't been possible for the terms of that new e-privacy regulation to be negotiated by the 25th of May 2018. And so GDPR came in without the new e-privacy regulation. Since that time, negotiations have continued. They have finally got to what's called the trilogue stage, which is the final phase of European negotiation. But from our perspective, we have had Brexit occur in the intervening period. So the result of that is that the new regulation will no longer be directly binding on the UK. So it is going to be an even longer waiting game for us in the UK to see whether, when any new law eventually does come into effect in Europe, whether or not the UK will choose to follow suit and actually introduce equivalent measures for the UK. And it may well be that what we will see is that measures that would otherwise have been addressed under an e-privacy regulation will now be superseded by the data reform bill that we're seeing and may be addressed that way instead. Certainly in the issue of cookies, that is what we're expecting.
Thank you. I think that leads into another question that was asked actually. And it was asked a little bit earlier in relation to the first part of when you were speaking, and they've asked how do you think the proposed changes will affect customers that deal with the UK and EU? And they've sort of said, well, we suspect the divergence will increase the burden on businesses.
And I think yes, it's hard to argue with that statement, to be honest. Obviously, the stated intention from the UK government is that we are trying to reduce our compliance burden. We're trying to do away with a lot of the red tape and the box ticking. But the reality is that any situation where we're having to deal with two different legal regimes is quite challenging. And what we've seen a lot post-Brexit is people are recognising the fact that we do now have a UK GDPR, which is technically a separate bit of legislation, but actually in practice, what has been said, other than in respect of the international data transfer issues that I've covered, is, well, the requirements are still materially exactly the same. So we don't really need to think about whether it's UK or EU, because if we're dealing with one, we're dealing with the other. And obviously that could change. But I think what we are likely to see is a reduction in the burden in the UK. But I think it's reasonable then to assume that if somebody is just subject to UK GDPR, they may actually be able to reduce some of their compliance burden. They may be able, for example, to stand down their DPO. They may be able to stop worrying about keeping up a detailed record of processing. They might be able to throw up some extra roadblocks to data subject rights requests, for example. Whereas those companies which are subject to both UK and EU GDPR are going to be in a position where they will either have to accept, right, we need two different approaches here, or what tends to be the more likely approach in practice is that they go with the highest common denominator. And in that case, it's going to be a question of staying with all of the EU compliant measures that they already have, rather than really being able to take advantage of any of the kind of lightening of the compliance burden that we might see in the UK. So,
thank you. I thought that might be your conclusion to that, because it always seems to be the case that where there's a divergence, you end up going, rather than having two systems, you go to the higher one, because, you know, then you're satisfying both, aren't you? So.
Exactly. And I've got I've just noticed a couple of questions that have come in that I think are more within your wheelhouse. So I'm gonna pose those to you, if I may. And the first one is, how do you go about valuing a claim, a data claim?
Well, there are two elements to a data claim. The short answer is one part's easy, one part's really tricky. So the element of pecuniary losses or financial losses are relatively easy, because of course they just have to quantify them. So if X amount walked out of their bank account, or they had to pay for something to be replaced, whatever it may be, a driver's license or whatever, those are nice and easy. It's £50, it's £100, whatever it is. The one that's difficult is the damages for distress element, because what one person can, well, we don't have, you know, historically for personal injury, I don't do personal injury, but there's a nice catalogue of exactly what every injury is worth. So, you know, you get X amount for a broken leg and so forth. We don't have any of that here in this area, and we don't have enough cases to get a clear indication also of what the range looks like. There was a case quite a while ago, which is still used as if you like, the benchmark. And we're not talking about the spurious de minimis claims, which we've touched on now, but genuinely where there is a breach and it has implications. And that sort of put a bar around £750. It's not an exact science. And we just, as practitioners, use it as a sort of guide. We know what the breach and the damages suffered in that instance were, and therefore we know if it's worse, it's going to look a bit more. If it's less, well, then it looks a bit less. Oddly, there are some cases where there were what we would term quite serious breaches. You know, they had really significant impact. For example, the disclosure of addresses of people who were at risk of harm because they were refugees, and they were at risk of harm from people from the country from which they had arrived, and they were given what feels comparatively a low amount. But we haven't had enough cases generated with enough different details to be able to give us a good indication. We have to go on a feel based on those cases, and that starting mark of £750 for what is a relatively, it's not a minimal trivial breach, but it isn't so heinous as to have caused real harm to the individual, is where we kind of pitch it. Sorry, that's not
Okay,
very specific.
no, that is very helpful. And actually picking up, going back, we've had one more question in which I think follows on quite nicely from that, which relates to those really spurious claims. And we've had a question that says, well, what do you actually do? How do you deal with what may appear like a completely spurious claim? In practice, what would you suggest people do if they get those through their door?
I suppose it depends how risk averse the organisation is. So if it looks like, if it's a cookie monster type letter, if you like, there's a good argument for saying ignore them and see if anything comes back of it, because what they're not about to do is rush off and issue a claim, probably because their modus operandi is to get money for effectively nothing, and so going to court would require them to pay a court fee and put some effort in. So they're more likely to come back or let it drop and pick on another organisation. So if you're feeling really robust and it's a cookie monster type letter, obviously do go and check your policy to make sure everything's compliant. But in terms of the letter itself, maybe park it, see what comes of it. If you're less risk averse and you don't like having things sat there unanswered, or if it looks like it has, or if it comes from a solicitor, for example, representing them, can adopt the more robust approach using the cases we've highlighted today. Obviously carry out an analysis when there's been a data breach, see what it looks like. Is it one of those where it's tiny one email, or there have been some where information wasn't actually taken in the end because although there was an attack, the measures in place prevented access to the data, and therefore it turns out that no data was lost, no data was accessed, but there are still people trying to bring claims on the back of that because I can't understand why, but they are. And so those ones, you can carry out the analysis, provide a response that says, we have done what we need to do, we've checked what the position is, you haven't lost anything, or we've lost one piece of information and actually it didn't have anything of particularly serious, or the level of information that was contained within it, and therefore we don't consider that you have a meritorious claim, and use the examples of the cases that I provided earlier to support those contentions. If it looks like it's more serious, obviously you need to do something more about it, and then an assessment can be carried out about whether you make an offer off the bat and try and draw it to a conclusion quite quickly. Underlying all of it is, of course, an investigation into what happened within the organisation and checking that breach and the allegations. But it's a varying response depending on what's coming through the door. And we're always available to have a quick chat with clients, talk them through how they want to approach it and what the risks are in terms of the particular scenarios with which they face.
Excellent, that's really helpful. So obviously your appetite for risk is going to play quite a big part, but do take the time to actually understand whether it really is a spurious claim or not before you decide to take a more gung-ho approach to potentially ignoring the claim.
Yeah, absolutely.
Perfect.
I don't think we have any more questions. So I want to thank you all for joining us today, and we hope you found it of use both practically and informatively.